this morning. CEO, are we done with the prayers and the national anthem? CEO, can you hear me? Are we done with the national anthem? Can you hear me?
Yes, we can hear you.
All right. I'm confirming we are done with the national anthem because I'm just joining not quite long.
No, we are not done with the national anthem. We are just about to commence. I just saw you and then I thought it wise to reach out to you to say maybe you can welcome our participants and our guests, speakers, and panelists. Then we can say our opening prayer and then recite the national anthem before we proceed.
Okay, I will take it with the welcoming address. So let's start as it is on the program. Let's start with the prayers and then our national anthem. Then I'll take the welcome address.
Okay, thank you very much, Ma. So, will someone volunteer to pray for us?
Okay,
let's commence.
Let's pray.
All right.
Are you hearing me?
Yes.
Father, we thank you this morning for this occasion. We thank you, Lord, because we believe that you are everywhere, and so you are here with us. We'll commit this meeting into your hands. And Lord, we say, oversee it. And at the end of the day, let your name alone be glorified. Thank you, our Father, for in Jesus' name we are prayed.
Amen.
Amen. Amen.
Amen.
Thank you. Thank you. Thank you very much. As we commence, I hope that the closing ceremony will have someone from the other faiths to conclude the prayer for us. So thank you very much, man, for giving us the permission to proceed. We are going to just say the national anthem, and I will, let me share this. Okay, so we will say the national anthem. I don't know if you can hear me. So maybe after the count of 2 or 3, we will proceed.
You don't have the national anthem to display on the screen? Okay.
Your Excellency, ma, are you saying something?
Yes, we can proceed. We can proceed.
Okay, thank you. Okay, so, all right. After the count of 3, we'll proceed. 1, 2, 3.
Our flag shall be a symbol of truth and justice. It gives a battle honor, and this wisdom and to hand unto our children a family that's oh God of all creation, grant us our request. Help us to the beautiful. Where peace of rest and plenty. Nigeria, be blessed.
Thank you for that. I think next time we'll just play it so that we'll have a uniform national anthem. So once again, good morning, everyone. My Lord, Honorable Justice R.S. Oladoja, Mr. Agada Elachi, Senior Advocate of Nigeria.
Doctor.
Doctor, sorry. My apologies. My profound apologies. Dr. Agada Elachi, Senior Advocate of Nigeria. Mr. Ifeanyi Anago, a fellow of the Institute of Quantity Surveyors and other ADR processes. Mr. Valentino Buro, Mr. Samuel Otareren, all members of the esteemed ADR community. I wish to humbly welcome you to this first quarter induction of Shati. We're honored to have you grace this occasion, and it is a privilege to sit and listen to you this morning to discuss the topic positioning for a global ADR practice, the role of mediators in the 21st century. And I'll also add that the role of the Nigerian mediator in the global sphere of ADR. I wish to use this opportunity to warmly welcome you and to thank you for accepting our invitation, taking time out of your very busy schedules to attend to our programs. We're indeed deeply honored and very, very grateful. Thank you so much for coming. I also want to thank the inductees for trusting and believing in Shati, for taking your time to go through the rigorous training of a whole week, writing your assignments, your assessments, and you have succeeded in passing all your exams. And today you are going to be inducted into the body of mediators under the training of Shati, under the able tutorship of so many very experienced resource persons. And we believe that after this induction, you will make a difference in your area of life, in your sphere of life, and in the ADR community at large. We're so grateful that the ADR community has received, or it has been birthed into the community, a new law, the Arbitration and Mediation Act 2023, which captures mediation as a very vital tool in dispute resolution. And the time to acquaint ourselves with the skills of ADR, it's now. And I believe with the very rare opportunity we have this morning to have our very own under the student who will say the guru of a particular subject. So the guru of ADR today is going to dissect how we will position ourselves and take advantage of this maiden law and its operation in Nigeria. I want you to be very attentive, take down notes, because it is not easy to have this caliber of persons to discuss what we're going to discuss this morning. So I wish to thank you for coming once again, and I I believe that we are going to have a very robust discussion this morning. Thank you very much, and God.
Thank you very much, Ma, for that wonderful opening address. Next, we're going to just go into a brief introduction of Shati and its governing body members. And so, Settlement House Area Training Institute is an institution that is registered as a company limited by guarantee. It is registered for the purpose of training and certification in mediation, arbitration, negotiation, and other ADR mechanism. It has been fully in operation for about 3 years now, and we started our certification program in 2021. And since that time, we have trained and certified about and inducted about 4 sets of mediators. We are hoping to introduce our arbitration certification training very soon, and we are working on the curriculum. Once that is done, we are going to let the area community know, and then we are going to reach out to our participants who want to take advantage of the arbitration training. Having said so, Settlement House is a unique institution, and as you can see in our website, we carry out trainings. If you want to know about us, you go to our website. If you go to the homepage, you'll be able to see some of the activities that we do. We are into training, and then we have our vision and mission is as contained. We want to ensure that ADR is adopted as a vital means of dispute resolution. And so we want to ensure that we create an informed and peaceful community through which alternative dispute resolution or appropriate dispute resolution will be considered the preferred dispute resolution and conflict resolution mechanism, both for our lives, for our business, and for our different individual faith. To achieve this, we have several missions which are stated there, and that is about the institute. We also partner with institutions like ABU, Kaduna State College of Education, and the rest of them to see how we can also provide training and education to those who may not be able to afford that appropriately. The members of the governing body of Settlement House ADR Institute include Professor Timothy Burrows. He's a professor of biochemistry in Kaduna State University. We have Mr. Ifeanyi Anagbo. He's a member of the governing body of Settlement House ADR Training Institute. He is an ADR practitioner and a lawyer, practices in Abuja. We also have Honorable Dorcas Levy, is a member of the governing body of Settlement House ADR Training Institute, and she is actually presently the current director of this multi-door Kaduna State multi-door courthouse. We also have Professor Andrew Andon Akume. Is a professor with ABU. He's a professor of law from Ahmadu Bello University. We also have Mr. Nancha Nangwa. Mr. Nancha Nangwa is a lawyer. He's an ADR practitioner and a notary public. He practices here in Kaduna State. We also have we have Mr. we have Professor Oladipo Agbola Folorunsho. He is a professor of mechanical engineering with the Nigerian Defense Academy. We have our very own Roskana Galadima Ankama. She is a lawyer, a lecturer, a mother, among several other things. She is the chairman of the governing body of Settlement House Area Training Institute, and she has been recently appointed as a member of the governing body, governing council of the Nigerian Institute of Chartered Arbitrators. We are actually fortunate to have her with us. We also have with us the we have as member of the governing body of Settlement House, we have Mr. Fola Alade. Mr. Fola Alade is a professional mediator, he's a global mediator. He mediates for the United Nations. He mediates and trains internationally, and is a very known figure in Lagos, Nigeria. We have our very own Oladi Kotolani. He's a senior advocate of Nigeria, and he is a legal practitioner and an ADR practitioner, both mediator and arbitrator. He is based here in Kaduna, and he has been very, very instrumental in the propagation of ADR in Kaduna State. He has been our leader in the formation of the ADR community, where all the ADR institutions come together. We also have Associate Professor Rita Bosan. She's a professor of English language in Kaduna State University. She's a member of the governing body. We also have Ms. Janet Nanchan. She's the secretary of the governing body of Settlement House. We also have our patrons. Most of our governing body members are also part of our patrons, but among those I've not introduced, we have governing body members that sphere across all other parts of the our professions or areas that we want to cover. So I want to just mention Dr. Shein. He is the chairman. He was the chairman of the Medical Association of Nigeria, Kaduna branch. And we have Mr. Oluda Abola. I think he's in Netherlands presently, and he's a patron. We have Mr. Mohammed T. Mohammed, MT, popularly known as MT Mohammed, is a patron of this great institution. And we have architect Bulus Drambi. He's an architect by profession. Having said so, we also have some volunteers. So this is just briefly about the Settlement House Area Training Institute. And if you want to know about our training, the trainings we offer, you check our website. We offer training in arbitration. We do online dispute resolution. We have our cooperation with educational institutions. We offer dispute resolution mechanism, ADR skills. We do emotional intelligence, do mediation advocacy. We do training on mediation skills, techniques. We do arbitration advocacy, restorative justice. We do training on arbitral registrars and secretaries, training on construction arbitration. We do training on medical disputes, among others. So this is briefly about Settlement House ADR Training Institute. So having introduced the institute, we want to go to our next agenda for today. We are going to go into the keynote address, and for us to go into the keynote address, we have our distinguished speakers in the house. We have our speakers in the house, and we are honored to actually have them all here with us. We first have as our keynote speaker today, Dr. Agada Elachi. He is a senior advocate of Nigeria. Let me see if I can just share its profile with us so that you see it. Yes, we have Dr. Agada Elachi. He is a senior advocate of sorry. Can you hear me, please?
We can hear you.
Yes, we can hear you.
Can you hear me?
Yes, sir.
Sorry.
Yes, we can hear you.
Okay.
We can hear you.
Okay, thank you very much. I was just introducing our Dr. Agada Elachi, who is the keynote speaker for today. Dr. Elachi is a senior advocate of Nigeria. He has a PhD and is a fellow of the Chartered Institute of Arbitrators, United Kingdom, and he is a fellow of the Institute of Chartered Mediators and Conciliators. He has been the past president of the Institute of Chartered Mediators and Conciliators, and he's actually someone you want to listen to, you want to relate. What baffles me about him is his humility. His humility is beyond mention. I believe he's actually his relationship with God has actually influenced the way and manner he does things. Our panelists for today, we also have our very own Honorable Justice Rabi Oladoja. Honorable Justice Rabi Oladoja, as you can see on her profile, she is an ADR practitioner and expert in ADR. She has been a deputy director at the Kaduna State Multi-Door Court House before her elevation to the bench as the High Court judge of as the High Court judge in Kaduna State. She's very humble and she has always been available when we reach out to her. The next panelist that we have is our very own Mr. Boboro Valentino. Mr. Boboro Valentino is one amazing person to relate with. He is simple, gentle, kind, and very straightforward in the things that he does. He has been the very first person who was instrumental in the introduction of the mediation advocacy training in Nigeria through a collaboration with the Standing Conference of Mediation Advocates. He's a fellow of the Institute of he is a fellow of the Institute of Management Consultants. He is the convener of the Association of Multi-Door Court House Practitioners in Nigeria, and he's going to be discussing a very important aspect of this induction. Thank you very much, Mr. Boboro, for joining us. We also have with us our very own Mr. Ifeanyi Anago. Mr. Ifeanyi Anago is an interesting person to note. Aside from being the fact that he's an expert in ADR, he's a fellow of the Institute of Construction Arbitrators. He's a fellow of Nigerian Institute of Chartered Arbitrators. He's an arbitrator to the core. In fact, he was instrumental in through the inspiration from God. He was instrumental in bringing about the concept of mediative conciliation, and we have the opportunity of hearing from him, like people say, from the horse's mouth. This concept has been patented in the United States of America. and he is a member of the governing body of Settlement House Area Training Institute, and we are indeed happy to have him in our midst. Last but not the least is our very own my dear friend, and forgive me, I forgot to mention that aside from Mr. Anagos's professional career, as a lawyer, as a quantity surveyor, and a known person in the area sphere, he's actually a pastor, and he has been very instrumental in preaching the word of God in everywhere he finds himself. You can find his profile stated there. We have with us our very own Mr. Samuel Orobosa Osanrere. Mr. Samuel Orobosa Osanrere is my friend, is my brother, and just like judges will say, they are brought my brother on the bench also to say. So he's also my brother in the area space. I am honored to have him. He's actually an amazing person to interact with. Mr. Samuel is a fellow of the Nigerian Institute of Chartered Mediators and Conciliators. He is a member of the Chartered Institute of Arbitrators. He is an accredited associate of the Standing Conference of Mediation Advocates, United Kingdom. He is a faculty member of Settlement House Area Training Institute, and he's also a faculty member of the Nigerian Institute of Chartered Arbitrators. He is a CEO of Pixar Curious and Associates. He's also an ADR and peace organization. He does sensitization trainings and a lot of things. It's really amazing the kind of things that he does. He's very hardworking, and he's someone that you would love to listen to. Having introduced them, I will say that we're actually fortunate to have wonderful personalities with us. Having said so, we will just go straight to the keynote address. And the keynote address is for about 30 minutes or less, depending on how our distinguished learners takes it. So with the kind permission of the chairman of the governing body, I would like to welcome on board Mr. Dr. Agada Elachi, Senior Advocate of Nigeria, to deliver a keynote speech. We present to you, Your Excellency, sir.
New set of
who have been
thank you very
trained
much,
for 5 days, and they have passed their assessment, and they are looking forward to a brighter future as mediators, both in Nigeria and all over. We have participants who are resident both in Nigeria, in some African countries, and in the European countries. And some of them are lawyers, some of them are law students, some of them are professionals in different fields. Your Excellency, sir, you are welcome. Thank you.
Thank you very much. Thank you, and I intend to, because there's an array of panelists, and we have we're running behind time. I intend to just speak for about 15 minutes, setting the tone, and then other panelists can make their intervention, and then hopefully we'll take a few questions here and there. So I start by saying, good morning, my Lord, distinguished Honorable Justice Oladoja. A pleasure again, having the opportunity to meet you on this platform. The chairman of the council or the governing body of Shati, my co-panelists, distinguished ladies and gentlemen, and particularly our inductees. I want to start by congratulating you for getting to this stage of your career in your growth as an ADR practitioner, and in particular as a mediator. I also express my gratitude to Shati for giving me the opportunity to deliver this keynote address at this very auspicious event in the month of August. Interestingly, the last day of August. When Nanted contacted me, I was at a loss whether to accept this responsibility or not, bearing in mind the fact that I would have to give up my golf, which I play every Saturday morning, in my bid to try to stay fit and look as young and as handsome as Mr. Anago.
We are very grateful, sir. Thank you very much.
So, well, I have made that sacrifice today, and but I'm glad I did that. Hopefully, this opportunity helps me to make acquaintance with even more people in this field of practice. My today, I intend to speak to the topic of how do you grow mediation practice in the 21st century. But because I know that the people who are here already have heard so much about mediation, I like to maybe backtrack a bit and talk about ADR generally, and then dovetail into mediation, and then conclude with what my thoughts are about what the mediators must do in the 21st century to be able to practice effectively. So, so by way of background, alternative dispute resolution has become a critical tool and is a critical tool for us in the 21st century for resolving disputes. And of course, the benefit is that rather than resorting to traditional lawsuits, disputing parties can leverage on alternative dispute resolution mechanisms, especially processes like mediation and arbitration, to help resolve their disputes effectively. Now, the concept of resolving disputes outside of the formal court has a long and rich tradition, predating even the modern notion of ADR. So I'm sure that you've been told that our forefathers practiced mediation. So you are not doing anything new. You are only building on the traditions that our forefathers had. Of course, I will not bother defining what mediation is. I presume that you know. If you do not know what mediation is, then you have no business being in this room at this material time. Now, ADR is an effective alternative to litigation. However, one of the things that you must keep at the back of your mind is that ADR has not come to supplant litigation, but rather has come to work hand in hand with litigation. Of course, the obvious benefits of ADR as you find them, particularly, and I'll keep dovetailing and narrowing it to mediation as often as I can, particularly is the fact that processes like mediation are confidential, they are cost effective, and essentially they are overall efficient in helping to restore parties to their pre-dispute relationship. Now, let me quickly pause and speak to the issue of confidentiality just for the emphasis. You cannot talk about being a mediator if you do not know how to keep the confidence of what parties present to you. So the first charge I give to you as those who want to have an effective ADR practice in the 21st century is that you must uphold the principles of confidentiality. You must also make mediation cost effective for parties. But this does not necessarily mean that you do it for free. Let me also state that, because I'm sure that many of you have engaged and taken on this not just as a vocation, but many of you also are hoping to be able to make money. What I say to parties when it comes to the issue of how cost-effective mediation can be is to say, for instance, as a practicing lawyer, if you wanted to brief me to undertake a matter in litigation, you pay anything anything between the ranges of about 5 million to 20 million and so on. But in mediation, I may just be willing to accept 500,000 or even just 1 million naira to help you resolve the matter timeously and cost effectively. So overall, mediation has that efficiency and effectiveness. Now, with the growth of ADR, there's now a lot of things that as mediators you need to contend with. So we cannot talk about mediation practice in the 21st century without having a fair understanding of how we came to where we are in the first place. Like I said, historically, we have always had the benefit of mediation practice, ADR practice, even cultural arbitration as part and parcel of our traditional system. Now, while the formal methods of ADR have existed for centuries in various jurisdictions, the formal ADR with standardized procedure emerged properly in the 19th century. So you had countries like Canada, Pakistan, India, and UK and the US who were adopters of the early adopters of the formalized process of mediation. For us in Nigeria, mediation, ADR practice and mediation became formalized in around the year 1999, particularly when we had the setup of the organizations like the Institute of Chartered Mediators and Conciliators, which was bettered in 1999 as a Nigerian Association of Mediators and then metamorphosed into what it is today. We had the Lagos State Ministry of Justice, which set up this first Citizens' Rights and Mediation Center to provide free dispute resolution services to indigent Lagosians. So this set the tone for what we now call the mediation practice in Nigeria. Of course, with time, the Lagos State set up the multi-door courthouse, and then Abuja followed suit with the establishment of the Abuja multi-door courthouse. And today, we have multi-door courthouses in Kano, in Kaduna, and in a host of other locations all over Nigeria. So these are some of the developmental steps that brought us to where we are. Now, you cannot also talk about 21st century mediation practice without now taking note of what are the modern trends in ADR? What are the things you must keep your mind on as a mediation practitioner? Well, some of the things that as a mediation practitioner you must keep in mind is the fact that with the growth of mediation and with the growth of ADR, we are now having what we call modern institutionalization of ADR. So you have, for instance, in Lagos State and also in Kaduna, the incorporation into our high court rules of the practice of mediation. You have, for instance, the establishment, as I mentioned earlier on, of multi-door courthouses. You also have other soft laws internationally and locally, like, for instance, the IBA guidelines that relate to mediation practice, the Singapore Convention on the Enforcement of Agreements reached via mediation. All of these are modern institutionalization of ADR and mediation, which as an ADR, as a mediation practitioner, if you want to practice in the future, you must keep your mind on. Then, of course, we will now have the rise of ADR institutions, many of them, including our own Shati, which is here moving the process forward. Then, very importantly, and I'm happy that the Madam Chair of the Governing Board mentioned it, you have the codification of mediation laws. In our own particular case, the passage into law last year of the Arbitration and Mediation Act 2023, which has put mediation, even though we had every opportunity, other legislations had mentioned mediation, had recognized mediation, this put mediation center stage. And then, of course, online dispute resolution practice. You cannot be an effective mediator in the 21st century without keeping your eye on ODR. And ODR presents is an innovative method that helps that the handling of disputes through information and technology platforms. So as a practitioner, you must keep this in mind. And one of the beauties of this is that it has gone to, whilst mediation used to be, it was popular for being cost effective, this is even made mediation more cost effective than it used to be. Then we cannot ignore the emergence of hybrid models, hybrid ABR models, and some of them you are probably familiar with already, ABMED, MEDAB, and then, of course, I'm happy that the man who coined mediative conciliation is here on the panel with me today, and I'm sure he will say a word or two about mediative conciliation. I have, over the years, in the course of my practice, developed something which I personally call LeadMed, which is recognizing sometimes the fact that parties are reluctant to go to mediation, and that some people are so rigid about their understanding of dispute resolution. I have now embraced, first of all, beginning the journey in mediation, and then leading it into beginning a journey in litigation and then leading on to a settlement in mediation. And I found it quite effective. Indeed, I'm currently doing a matter now where that is what we are also doing. And then, of course, you must, very importantly, take into cognizance in the 21st century in your practice as a mediator, specialization. So not just, and I'm happy that many of you are here as people who now want to specialize in mediation. But even within the confines of mediation, there are levels of specialization. You want to be a facilitative mediator. You want to be a transformative mediator. Do you want to be an evaluative mediator? Do you want to be a community mediator? Do you want to be a family mediator? Do you want to be a special needs mediator? These are the things that as mediator, you need to begin to address your mind to as you walk towards your practice in the 21st century. Then anybody in the 21st century who does not pay attention to artificial intelligence is looking to fail. So the mediator in the 21st century must also pay attention to the fact that AI has come to stay. Indeed, some have argued that AI is the 21st century game changer in all parlance, including ADR practice. And of course, ADR practice covers mediation. So these are the things, these are some of the things that I want you as budding mediators, as those who will start your journey in your career in this field to begin to think about. And the purpose of a keynote address really is to get you thinking. My job this morning is not to teach you anything new. My job this morning is not to provide any solutions, but rather to agitate your mind so that you can begin to ask questions about how you can make the future better. Those of us who have been here have done what we could do. We keep doing, but we expect that those of you who come can do more. Now, if you apply all of these things that I have tried to showcase, what are some of the major benefits and prospects that we will see in the 21st century? Swift resolution of disputes will be enhanced. Cost effectiveness will be greater. The very one that is dear to my heart is that you will provide your clientele and the people you work for tailored solutions. So not just do you provide them solutions that meet their needs, but they are tailored specific. It's like a tailor making a cloth for you and all that. So because in some cases, for instance, if I may come to the difference between facilitative and evaluative mediation. In traditional mediation, we are taught that the mediator cannot suggest any outcomes to the parties, should not give any advice, should not do any assessment. In evaluative mediation, the mediator is allowed to do that. So you need to look at what is the context of the practice. Am I, for instance, a mediator practicing within the confines of a court-connected ADR center? If you are, then maybe some degree of evaluative mediation is what you need to be considering. Then, of course, global reach. It's a tool. You meet the advantage that embracing AI, embracing online dispute resolution gives you as a practice mediator is good. And I'm happy that today we have, amongst those of you being inducted, practitioners who are based from different parts of the world. One of the things that has helped my career as a mediator is that I have not limited myself to practicing in Nigeria. I have practiced everywhere. Next week, I'll be away in Accra, again, doing my mediation work. So this is the advantage that it gives us. And then with the emergence of laws and treaties like the Singapore Convention on International Commercial Mediation, settlement of agreements via mediation, enforcement of settlement agreements, you now have mediation applying on a global stage for commercial disputes. Before now, mediation agreements, there was no way to enforce it internationally. Now you have that. So as an ADR practitioner in the 21st century, these are some of the things you want to begin to look at. Then, of course, you can also begin to look at sector-specific expertise. Do I want to be a mediator in the oil and gas sector? Do I want to be a mediator that offers family services? Then lastly, do I want to be a mediator whose focus is community-based solutions? Because there are a lot of things going wrong in our community today. For instance, we had the protest recently. How many of us as mediators or budding mediators saw it as an opportunity? For me, I saw it as an opportunity. And on all the levels that I could relate, I was able to encourage people to engage in that. So as I conclude, I want to now say, what must the mediator, by way of summary, what must the mediator in the 21st century do? Be conscious. I'll give you a few bullet points, but the first is to note, and I'd like you, if you have a pen, to write that down, that the mediator has to be a catalyst for change and a community change agent in the dynamics of the dispute resolution practice. I repeat that. The mediator has to be a catalyst for change and a community change agent in the dynamics of dispute resolution practice. How will you do that? My suggestions are that: one, you identify early warning signals, which means that as a person, you must be on top of the game. You must be the kind of mediator who is proactive in your approach to the practice. Two, you must walk the talk. What does it mean? That is to say, you must live like the mediator. At ICMC, where I had the privilege of training, for me, I'm still training, and I was president for, and I just handed over. One of the things we say is that the mediation is a way of life. So if you want to be a mediator, it must be a part of your life. You cannot divorce your mediation practice from your life. You cannot be a quarrelsome person in one regard and then a mediator in the other regard. It won't work. The third thing you must keep in mind is to promote dialogue at every opportunity that you have. In promoting dialogue, you must also facilitate dialogue. Now, these are interesting dynamics, and you may think that is very easy, which means, but the point I want to emphasize is that one of the qualities that the mediator has as a dispute resolution practitioner, unique and different from other practitioners, is as an arbitrator, I cannot on my own intervene in a dispute to help parties. I must be invited. As a conciliator, I cannot. Parties must appoint me and invite me. A judge cannot come to intervene in a dispute, but a mediator can suo motu, as we say in law, can take steps to assist parties. So you must promote and facilitate dialogue. You must specialize your practice focus. Don't be a jack of all trades and master of none. I stated that before, but I restate that again. And then lastly, you must be a mediator who has global thinking, but applies it locally. So I like to call it global thinking, local application. Distinguished ladies and gentlemen, my lords, chairman of council, I thank you for your attention. And I hope that with these few minutes, I have been able to agitate your mind as to what you should do and what you should begin to aspire to do as a practitioner in the 21st century. Not just the traditional mediator that you've been taught that you should be, but what are the things you are going to do differently to be able to answer and address some of these new areas and new developments that are coming up. I thank you for your attention, and that is the end of this keynote address. Thank you.
Thank you very much, Your Excellency, sir. I was paying keen attention to hear and benefit from this, and it has been very, very amazing. That's very, very wonderful. I want to appreciate you on behalf of the Institute for that well delivered paper. So having said so, thank you very much, sir. We want to go into a panel discussion, and we have all the panelists here with us. And first, I will want to give honor to Her Excellency Justice Oladoja. She has been here with us right before even 9 a.m. And I had to call my Lord and say, my Lord, you can come in around 10 o'clock. She said, no, she's ready. So since she has been ready since, permit me to first reach out to her to give us her own perspective on a very, very important and crucial aspect of AGR. Now, one of the issues and matters that has been of concern to users and practitioners in the alternative dispute resolution sphere is whether or not mediation especially is enforceable, and coupled with the fact that some people are advocating for a mandatory mediation, and then we discovered that the issue of voluntariness is very crucial in mediation. I want to ask my Lord, sir, what, in your own understanding, is the judiciary's role in advancing ADR mediation or ADR practices in Nigeria, so that people can build their faith and confidence, more so that we now have the Arbitration and Mediation Act? What is the role of judges from all levels in advancing and promoting ADR? You have 5-10 minutes to tell us all that you can tell us in respect of this. Thank you, my Lord. My Lord, you can mute. You are unmuted. Can you unmute?
Yes. Am I on now?
Yes, thank you very much, my Lord. Go ahead.
Yes. Thank you, Mr. Nanchan. First of all, I would like to commend the learned Sikh on a very loaded and guiding presentation, which any successful ADR practitioner needs. I would want to recommend to all practitioners to take to what he has just said. Once you take it, you are good to go. To add just a little before I go into the topic I'm supposed to handle, I will also want to add that as lawyers, we must understand that ADR is not here to take up your job as a lawyer. As the learned Sikh has said, it complements the conventional litigation process. So don't shy away from being an ADR practitioner, or don't shy away from encouraging settlement or taking ADR processes with your clients. As it has always been said, this is the in thing now. We cannot run away from it. And it is for you as a lawyer, ADR practitioner, to have that at the back of your mind, and to also propagate that to other lawyers that are non-practitioners, non-ADR practitioners, that this also is a viable outlet. And I will also want to add that for ADR to be fully achieved, I think we should, in fact, we must enlighten all stakeholders. And stakeholders here include particularly the public, because from where I am, I realize that many people don't even know the existence of ADR. They think that if you have any dispute, you must go to the conventional court. So we need to enlighten, to sensitize, to propagate, and to also publicize. Because if you don't publicize the activities of ADR, like if you have a center, or even you have an outfit for that, nobody will even know that that kind of outfit is there. So we must sensitize, enlighten, and publicize venues and programs so as to get to those who actually need those services. Now, to the role of judiciary, by the rules, by the Arbitration and Mediation Act 2023, it has made an extensive provision for the role of the court, right from application to enforcement of either awards or agreements, arbitral awards or agreements. So it is the courts. What I will add, I don't want us to bore you with the AMA provisions. We can always get it even online, or you buy copies of that. But the essence of the importance of court in arbitration, or rather in ADR process, is one, that is set to regulate the process, because at a point in time there were not such provision. When there is an award or when there is an agreement, since there is nothing to legally back such award or arbitration, some parties tend to misuse that process and renege from what they had already agreed upon. As you all know that even arbitration is a mutual concession between the two parties as to how it is going to be handled, and more particularly with mediation, which is mainly party driven. So even with that, some parties tend to misuse that and renege on the already settled and agreed awards or agreements. So with the court now, such agreements are taken to courts and they are enforced, and they are as good as any judgment of the court. So it will be hard and probably impossible for any party to such an agreement to now come tomorrow and refuse to abide by it. In the court, if most of our rules now, rules of court, whether High Court, in fact, even at the lower courts, High Court, Court of Appeal, and even the Supreme Court, there are provision, even before this AMA, that encourage settlement, ADR processes to be canvassed before coming to court, or even while the case is before the court. So the courts play a very important role, as I said, in regulating the activity, the agreement, enforcement of agreements. And even while cases are on, the courts is enjoined to even advise. In fact, now the AMA now is specific. It allows the court to advise, to suggest that you go for ADR. So, and in that, I've been in the AMA provision, which is a whole section, a whole schedule. The third schedule provides the guidelines for going about such. The case will be stayed. You go and canvass the ADR, then come back and enforce it. And if settlement is not reached, in some cases, because it is inevitable that it is not all cases that go to ADR that are amicably settled. Some actually fail to be settled, and they are returned to the court for continuation of hearing of the conventional hearing. So in a nutshell, these are some of the role that the courts play in the process of ADR. Thank you.
Wow, thank you very much, Your Excellency, Honorable Justice Oladejo, for that wonderful discussion. We really appreciate you. We value you. Thank you very much for reaching out for accepting our invitation. Anytime we reach out to you, and I know your contribution in ADR as a stakeholder will never go in vain. Thank you very much, my Lord. Now we have seen that in as much as agreements can be honored ordinarily by parties, where they voluntarily enter into, but where there is a mediated agreement or a mediated settlement, and parties or someone is not motivated to actually put that into practice or perform his own side of the obligation, you can reach out to the court, and the court can interpret that provision. It can give it effect, and if it is an award or it is a mediated settlement, it can be entered into consent judgment, and once that is done, the issue of trials and appeal is laid to rest. Thank you very much for that wonderful contribution, my Lord. Now, I would like to go to our very own Mr. Ifeanyi Anago. He is a member of the governing body of Settlement House ADR Training Institute. We are really happy and excited to have you. I can see you have been ready right from time to share with us about this concept of mediative conciliation. Now, let me give a little background. You know, the Institute of Chartered Mediators and Conciliators have been one of the major champions of mediation training, advocacy, and practice in Nigeria. Now, they are named Institute of Chartered Mediators and Conciliators. And we have the former president as the keynote, give us the keynote address. And we also have a fellow of the Institute, Mr. Ifeanyi Anago, who has developed or propagated this concept of mediative conciliation. Sir, I was privileged to be one of the pioneer secretary of the Association of Multi-Door Courthouse, and in that platform, we have distinguished personalities from different area institutions. And one of the heated arguments that came up one of the time in that platform was whether or not conciliation is no longer applicable in Nigeria because of the advent or the coming into being of the Arbitration and Mediation Act. So, sir, now that you have actually propagated this concept of mediative conciliation right from time, and it has been patented in the United States of America, we would like to hear your perspective on this concept of mediative conciliation and how it can aid and help us and serve as a catalyst for upholding a global area practice, and whether it is irrelevant as at today, so that the participants and these new inductees can know how to navigate their ways around it. Thank you very much, and over to you, sir.
Well, good morning, ladies and gentlemen. My Lord Justice Salisu Oladoja, thank you for your immediate past contribution, intervention. And I also thank Dr. Agada Lachi for his keynote address that actually summed up a lot for us going forward. And then I also want to thank him for being the first person, the first chairman of BAR in Abuja that gave a national interview to a national newspaper on mediative conciliation when we were just starting to fly the kite, as it were. As it were. He may have forgotten, but I remember. You know, so can I quickly say something as I wrap up my own part of intervention? Now, comments were made about lawyers who had gone out of their way to try to frustrate ADR on account of not understanding how it affects their practice. And I thank God for what Elachi has said and what my Lord has also said. You know, in things like this, a typical average lawyer, when he hears ADR, somebody has said what he hears is alarming drop in revenue. And, and it shouldn't be so. It's actually sometimes an improvement in revenue if we know how to navigate the process, as it were. Now, mediative conciliation, I cannot talk too much about it because there's no time. I can only highlight the fact that it was actually Kaduna driven. I was in Kaduna when the concept was formulated. I formulated the concept by the grace of God. I will normally put it this way. And what I try to do, I'll just give you a summary of what transpired and then how it has traveled to where it is today. And let me say this, please, quickly up front. It has not been patented in the US. It was acknowledged in the US and implemented, yes, implemented by America's Department of Department of Justice. Used it to settle disputes. So there is no official patent, as it were. But in Nigeria, there is. Yes, there is. Registered with the Ministry of Trade and Investment. So let me say this quickly so that maybe later on, as you read materials, you can understand the context. There was a dispute in Abuja here involving a hotelier and his contractor over an issue on a hotel project here in Abuja. And they were going to go to court because the contract didn't provide for arbitration. Somehow the consulting architect, who is Kaduna-based, asked that they should refer the matter to me to see whether I could resolve the dispute in question, especially because as a QS, I'm used to construction disputes. And then also having been trained in arbitration, in mediation, that I should be able to navigate a process for them. So I accepted to intervene, as it were, and the meeting was scheduled. And that day at the meeting hall, actually, some things happened that became the foundation for what we're talking about today. On one side of the hall was a table arranged for the client and his team. On the other side was a table arranged for the contractor and his team. And I was just put at the center with a table. And suddenly, I'm saying this with all due respect and all due glory to God, because I didn't know what to say that day. But somehow, an inspiration came. And I asked the parties to please shortlist their points in dispute. I asked the parties to shortlist their points in dispute. And each party shortlisted on a page of paper their point in dispute. And when I looked at the disputes, I saw that some were concurrent. In other words, what you have here is what you have here. So I shortlisted them, all of them, into one page, about 14 points. So there and then, I had this out-of-box thinking. Let me start with mediation. And I told the parties, I said, the thing I'm going to do now is mediation. In other words, as I call up each point, I will assist you, facilitate you resolving the dispute by yourself. And whatever you agree, I will note it down as the agreement. But if for any reason you fail to agree on any point, I, the neutral, whatever I decide on that point, you will accept it as final. Now, this is quite out of the box thinking. Because as I said it, I said, you either agree to what I'm saying and will continue, or I walk away. You can then explore other alternatives. And somehow, the parties agreed. And so we began to mediate. All those expertise in mediation that you know, you've been taught, we deployed them. And we're able to resolve 10 of those disputable points, remaining about 4. On those 4, I gave my decision. And because there had been a prior buy-in to the idea that if they fail to resolve, the neutral will give an imposed decision. There was a prior buy-in. Nowadays, it's formalized by an agreement. But that time, it was just a prior buy-in. And the parties just simply agreed, because that was what they had agreed to do. And they signed off. And that was it. That was it. They resolved themselves, and they paid me that time 20,000 naira in 1993. A lot of money today in dollars. So that was it. Then an opportunity came in the 2000 for presenting a conference paper in Calgary, Canada, at the Second World Congress of Cost Engineering, Project Management, and Quantity Surveying in Canada. And I was asked to present a paper on that. I was asked to present a paper on that. So that was the first time we had to go to international community with the concept. But then I didn't know what to do until I prayed. And when I prayed, the name came out to me that what I'm going to talk about, that thing that happened that day at that hotel was mediative conciliation. In other words, a combination of mediation and its facilitative skills and conciliation and its evaluative techniques. But then the only difference that it gave rise to a totally new thing, that where the parties fail to agree, whatever the third party neutral decides is final. And because they've agreed to it, as it were, it becomes enforceable. But then it traveled from that concept. After we came back from Canada in 2000, it traveled gradually to a point where now the parties will agree that if they fail to resolve any dispute, any point in contention, the third party neutral's decision will be final and binding and enforceable as an award, not just binding a contract, but enforceable as an award. And these agreements are put together before anything starts. They have to sign off on it. And that was how the Institute of Construction Industrial Arbitrators adopted it that time as Article 4 of their 1996 rules. And then the journey into the mainstream of legal practice or judicial practice began. So I can only say this in summary, that between 1993 and today, the journey had been long. But one thing has been this, that in every place we've applied this principle, it has secured 100% compliance without needing to go to court to enforce anything. Because the parties had agreed to it ab initio. The parties have seen the requirements of the mediator who transit as the conciliator, and so on and so forth. But let me say this by the wayside. Conciliation is actually basically evaluative, especially in Nigerian law, as it then was. Mediation is facilitative. But UNCITRAL, United Nations Convention for International Trade Law, had used mediation and conciliation interchangeably. So it's like saying the term applies both to facilitative dimension and evaluative dimension. So they're just like the same, like say 6 penny and a dozen, as it were, and half a dozen, as it were. I'll make more comment on that later. So can I just start saying formally now that mediative conciliation is a knowledge-based alternative dispute resolution mechanism. It's knowledge-based because you must know something about the issue in dispute. That combines the facilitative skills of mediation with the evaluative techniques of conciliation to offer a unique dispute resolution model with an assured outcome. What it means is that once you enter into the process, there must be an outcome. Outcome either by word of settlement, agreement by the parties, or imposed decision by the third party neutral. And whether it's by settlement agreement or imposed decision by the third party neutral, everything is collapsed together and made enforceable as an award. Made enforceable as an award. And the implication is that the parties had to agree at the beginning of the process that that is the outcome they want. And I will tell you that because there was no law backing up this concept, at several fora where we have made a presentation before judges, what flew the kite was, look, we're dealing with commercial agreements, whether domestic or international, under the panoply of then Arbitration and Mediation Act, Arbitration and Mediation and Conciliation Act, as it then was. So the understanding is that, look, because it is a commercial agreement and parties are empowered to decide on what they want done in a civil matter of commercial variety. So if parties say that the outcome of this process is enforceable as an award, then so be it. And the courts found that argument appealing, that the parties decide what they want. The judge is there to interpret the contract between the parties. So if the parties say this outcome should be enforced as an award, so it should be enforced as an award, because it is within the construct of what the parties have the power to agree on. And that has been how it has gained entry into the mainstream judiciary, as it were, before we are now formally invited in 2015 to train judges at the NJI on that concept, so that judges will know how to implement it and how to apply it. Now, quickly, I said it is a combination of mediation and conciliation and offers a unique dispute resolution model with an assured outcome. The parties in dispute will agree at the outset that they will first attempt the resolution of their dispute through mediation, failing which the neutral will conciliate by making an imposed decision. This agreement is primal and primary. Now, the mechanism works only if the following conditions are met. Number one, that the mediator conciliator is knowledgeable in the area of dispute. Is knowledgeable. It's not like just a classical mediator whose job is to facilitate parties resolving their matter. No, he must have knowledge in the area of dispute, so you can evaluate, as it were. That's number one. Two is that the parties must have confidence in the ability of the mediator to be unjust and biased. Very crucial. So the mediator must be somebody who has been known for walking his talk, who has been known for demonstrating those competencies that make a mediator unique, as it were. So he must be somebody who has inspired confidence in the parties. Number three, parties agree and consent to being bound by the decision of the neutral if they fail to resolve through mediation. Very crucial, because it is party-driven. Parties must agree ab initio that this result, they are willing to abide by it and live by it. And it will be enforced if they fail to comply the way they have agreed. Number four, a party's refusal that happens classically in mediation, as it were, to attend an adjourned session is deemed to have failed to resolve by mediation. And then that party will consequently await, receive, and be bound by the decision of the neutral. If you, in classical mediation, you can walk away. So long as agreement has not been reached, you can walk away. And even when agreement is reached, it's enforceable in contract. But in this concept, you can't walk away, having agreed ab initio. If you walk away, it will simply mean that you fail to resolve through mediation, and therefore, the third party neutral will now give a decision that is enforceable as an award. I must keep emphasizing this. Enforceable as an award, because the parties had prior before that time agreed that that's how they want it enforced. Then number five will now be having agreed to be bound by the decision of the neutral. That decision is final and binding on the parties and will be treated as an award. Now, these are the issues that accompanied this concept. And the first time we made a presentation on that at National Judicial Institute, the question judges were asking is, given that the CJN then, Mustafa Mohammed, had just allowed that ADR resolved disputes can begin to count in quarterly returns for judges in their promotion, as it were. And then the committee set up by the CJN now came up to say, look, it's not a question of just merely referring the matters to multiple courthouses and then bringing in a plethora of consent judgments. No, you must show what you did as a judge, the active role you played to be able to resolve the dispute. So it was at that meeting, that conference, that seminar, that we made it clear that the way that requirement can be accommodated is the fact that some jurisdictions like Ogun State, like Lagos, like Abuja, in fact, Ogun State and Lagos that time had what they call pretrial conference within their High Court Civil Procedural Rules, pretrial conference, where after the issues have been joined, the judge will now enter into his chambers, call the parties, and attempt an amicable resolution as provided by the High Court laws, as it were, whether it was for civil and sometimes in some cases criminal matters that are not grievous, are not felony. So it's at that point of pretrial conferencing, which in Lagos is known as pretrial case management and scheduling, pretrial conferencing, when the judge is attempting to resolve the matter amicably, that mediative conciliation as a concept is introduced. And the parties will be told how it operates. That we're going to try mediation. And if it fails, the third party neutral, the judge, will now give his decision. And both parties are bound to accept it. If they fail to accept that option, then they can explore other options. But if they accept this option, then it goes through. And judges that have tried it, some of them came back to say, look, in one sitting, the matters were resolved. And they were resolved and implemented as consent judgment, as it were. So it helped them in their dockets to improve their returns, as it were. So they could show what role they played in making it happen. So most judges today that I'm in touch with, under these various high court rules of the state, and especially under the orders providing for amicable resolution, now exploit this opportunity by introducing MEDCON as the concept that they use to resolve disputes, and then it becomes enforceable as a consent award. So having said this, I think I should round up now by saying that the journey has been long, but as of today, it has entered into the windows of quite a number of multi-law courthouses, and then judiciary is adopting it piecemeal, as it were, as the occasion demands. Of course, the international dimension is that American Department of Justice had used it in resolving a number of cases. It was used in 2005 to resolve dispute that emanated from Hurricane Katrina, and 2010 for dispute that emanated from the Gulf of Mexico oil spillage. So international applicability had been actually established before it became domesticated, as it were. Now, finally, the New York the Singapore Convention of 2019 now provided that mediated settlements can be enforced as a court judgment or an award, as it were. In other words, the concept we thought about in 1993, by the grace of God, had now gained currency up to the point when, for international commercial contracts, Singapore Convention now said settlements can be enforced as an award. But because before 2019, it couldn't be enforced as an award. The best enforcement program is as a contract, which means if the parties fail to agree, you now go to court and begin to take out the normal processes required for enforcing contracts. But Singapore Convention now brought it to 2019 to say, look, mediated settlements can be enforced as an award or court judgment. As the case may be. But what MEDCON does is that for Singapore Convention to become applicable, there must be a mediated settlement. The parties must agree.
Thank you very much, sir. Much, sir, for that wonderful presentation on the concept of mediative conciliation. I hope that the parties are actually, the participants and the inductees are actually taking note of some of these vital, important aspects of things that they can put as onions in their new practice. Thank you very much. So having had that wonderful perspective on how you can utilize the concept of mediative conciliation, more so that irrespective of the fact that it has been repealed in the, that we now have Arbitration and Mediation Act. When you look at the Singapore Convention and you look at the AMA, it all defines mediation as to include conciliation and any other ADR process that does not include a process where someone has the power to impose a decision. So mediation, conciliation, and all of those things they are all considered as one and the same. Thank you very much for that wonderful contribution, sir. We are very grateful. Now, having said so, I want to go on to our very own Mr. Valentino Boboro. Valentino Boboro has been very, very, very instrumental.
Hello, please. I think hello.
Yes,
hello.
Sir.
I had a dislocation. I had a network issue. So,
okay.
But you can continue. But I've just wrapped up the whole thing. I've just done that. You know.
You can have
continue.
You can have 1 minute to round up.
Okay. Just like I was saying before the disturbance, the Act talked about all those systems that are not subject.
Sir, can you unmute?
Okay.
Hello, sir. Yes, thank you, sir. We have to mute everyone.
Okay, so I just said that military conciliation, the way it is today, lies side by side, collateral, lies side by side to the Act, because already by its protocols, enforceable as an award, and therefore lies side by side, the both Singapore Convention and the AMA Act as provided. So in summary, that's just the way it is. And it just requires just knowledge of the matter in dispute, mediative expertise, legal exposure, technical expertise too, and then you're as good as dry, you can fly. So thank you so much for this opportunity to address us on this matter. God bless you.
Thank you very much, sir. It's an honor having you. We are very, very grateful for always coming when we call on you. We are very, very grateful. So having said so, we want to go to our very own Valentino Boboro. Valentino Boboro has advanced experience in mediation advocacy, among others. He has been instrumental in enacting, bringing into, encouraging most of younger practitioners and those who want to go into the field of alternative dispute resolution. We are calling on him to help us look at, these are new sets of mediators that are going out there, and upon their induction, they'll start their practice and begin to develop a career in alternative dispute resolution. And we discovered that you have served as the convener of the association multi-local houses, and some of these inductees are lawyers, some are aspiring lawyers, and others from different professions. Would you like to address us, sir, and the participants and the inductees on the role of the multi-local houses, as well as that of lawyers, in promoting mediation in Nigeria, putting into consideration the fact that you are both a lawyer, you are a journalist, and the convener of the Association of Standing Conference of Mediation Advocates here in Nigeria. Please, sir, over to you.
Yeah, thank you very much, Mr. Nanchang, and maybe I should also thank you for giving my surname a double barrel. My name is actually Valentino Buoro. I do not know where the Buoro comes in, so but that's taking it.
Thank
so
you. Sorry.
Permit me to stand on existing protocols and to congratulate the inductees on their achievement, which is the beginning of a lifelong learning. My intervention on the role of MDCs and lawyers in promoting mediation may at some point be controversial. Are you hearing me? Am I being heard?
Yes, sir.
Yes, sir. Yes, sir.
Okay, yeah. So I'm saying that my contribution may at some time become controversial. The reason is this, but I do not have all of the answers, but I want to set the tone for further discussions on the topic going forward. When you talk about the role of MDCs and lawyers in promoting mediation, I want to see the multi-door courthouses as institutions that should promote an enabling environment for mediation, and also to publicize its own existence. Those are the key roles that I find for multi-door courthouses in promoting mediation. The enabling environment they provide is to accept matters into the courthouses and deploy their mediators to resolve those matters amicably. But beyond everything, I see the lawyers as the first line of contact for mediation promotion. And when I talk about lawyers, I'm not talking about all lawyers. I'm talking about lawyers that have bought into the concept and practice of mediation. As Nanchang rightly said, I was, in all humility, the person through whom mediation, the concept and practice of mediation advocacy came into Nigeria. Mediation advocacy, which is still relatively unknown in many areas, is the art of representing clients at mediation. Ordinarily in litigation, you have lawyers representing parties. But in mediation, lawyers and non-lawyers can represent parties in mediation. The mediation advocacy training designates lawyers as mediation advocates, while non-lawyers are designated as mediation advisors. They play the same roles, representing the parties in mediation. Non-lawyers are supposed to remain in their primary areas of profession. For example, a real estate mediation advisor should only take on cases in real estate mediations. Lawyers who buy into mediation are those we call mediation advocates. And of course, how would a lawyer promote mediation? I tell people that if you want to be a successful mediation advocate, first be a successful practitioner in your first line of practice. I heard the learned son talk about going around promoting mediation through his legal roles. I can only think that this may be done when matters come in for litigation. As a mediator or an ADR professional, he is able to determine at the outset what of those cases are suitable for mediation or ADR, and that's how he channels them. So successful mediation advocates will be those mediation advocates who are successful lawyers or who have active practice in law, so that when people come to you with matters, they come for a legal solution. Nobody wants to know your qualifications, as in how many degrees you have or whatever else. They have a legal pain and they want a solution. You as a mediation advocate who is a lawyer would know whether you want to pursue this matter through litigation or through mediation. And with the size of mediation advocates and mediation advisors that we have, they are the foot soldiers. They are the ones who are the first line of contact with disputants. They are the ones who will promote mediation by telling the clients what mediation is all about, what their expectations should be, and what roles they are supposed to play. The multi-door courthouses can only do that within a day or not even a day, a few hours, when the parties come for preliminary meetings. I have always argued that such preliminary meetings do not go to much when it comes to changing somebody's mindset about a process he or she wants to take. Because the first area that people look at is that they want to go and litigate. But now they are before an expert who says, look, there's a better option, and the better option is X, Y, Z. That will take a number of hours. That may take some days for you to do that. So while mediation courthouses house mediators and processes the issues or the dispute resolution itself, the first contact to promote mediation advocacy or mediation process is the mediation advocate or the mediation advisor. Now, having said that, I see some challenges in the promotion of mediation. And that is why it appears that mediation usage is still largely stunted in our jurisdiction. Why do I say that? I have issues with multi-door courthouses charging huge fees or substantial fees for mediation. When you go to the courthouses, the conventional courts, the filing fees are not 1/3 of what mediation courthouses may charge. The fee structure in litigation actually comes from what is the lawyer himself asking for. And then he asks for this and files the matter before the courts, which are funded by government. The judges are paid by government. The registry staff are paid by government. And the lawyers bring in their cases and prosecute them and get paid by their clients. So if, for instance, I now take a case to a multi-door courthouse and the case is priced for 120,000, 200,000, the question then will be, what do I, as a lawyer, get for bringing this? Won't it increase the cost profile of the ordinary people who mostly use mediation? So if it is going to increase the fee and the mediation advocate or mediation advisor finds it unprofitable, he is not likely going to go through that route. So what I am looking at is that I am proposing that for mediation to be properly promoted, the multi-door courthouses should provide an enabling environment to allow professionals like the mediation advocates and mediators to practice profitably within the courthouse system. Many mediators are discouraged today to take on cases in the multi-door courthouses because of what permits me, with due respect, I call pittance as your mediation fees. I know of courthouses that pay 10,000 naira per case. I know some major ones that pay 25,000 naira per case. For a professional who trained with some substantial money, has acquired some skills, complex skills, and all of that, it is not encouraging. If government is serious about mediation, peaceful resolution, it should take on the fees of the multi-door courthouses in all respects. I know that multi-door courthouses get funding from the government. They are also open to other funding sources, such as grants and donations. They can utilize that and maybe just take a fee for administrative fee for filing processes in the courthouses, and then allow the mediation advocates and mediation advisors a business, a profitable business, to bring in more and more clients. And at that point, the retail nature of the several millions of clients coming to the multi-door courthouses will make more sense than what we currently have of only a handful of people going to the multi-door courthouses. Respectfully, there are a number of multi-door courthouses that are underutilized as at today. Why? Because the concept of mediation is not being well promoted. Because even the multi-door courthouses themselves are government organizations. Majority of them are full government organizations. And you know that when you are within the government system, there is so much you can do by way of being flexible, by way of going into the market to publicize yourself, by way of doing so many other things. That may be different from a private mediation center. So talking about promotion of mediation, let me round off this way by saying that the larger army that can do this are the professionals, the mediation advocates, the mediation advisors, and of course, the mediators themselves. Look at it from this other point. How many mediators do the multi-door courthouses engage as members of their neutral panels? Just a handful if compared. So what happens to the army of other mediators that are out there? How do they make their businesses? So I look at the situation that beyond the handful of mediators that are in-house, the mediation system, the multi-door courthouses should be able to create a system that encourages all private mediations to take place. And when they take place, where the multi-door courthouses will make their money is when those settlement agreements are brought in to be registered for enforcement. So in this process, everyone wins. To our new inductees, let me advise that beyond the mediator skills that you have acquired, you also need to acquire mediation advocacy skills so that when you are not mediating, you can be representing. And of course, for those of you who are lawyers there, get to know that as lawyer mediators, you cannot mediate between your current clients and any other disputants. So in that area, your hands are tied. The only way you can operate is as an independent and neutral mediator who will mediate between parties that you do not know. And if you do this, you can take your settlement agreement to the nearest by multi-door courthouse for registration for enforcement. That is why at the inception of the Multi-Door Courthouse Practitioners Association, we said that multi-door courthouses, the association, was not limited to only those who were in-house. Anybody who does business with the multi-door courthouse is a multi-door courthouse practitioner. If I, as an independent mediation advocate, take matters to the multi-door courthouses for resolution, I'm a multi-door courthouse practitioner. If you, as an independent mediator, who is not lucky to be on the panel of the neutrals in the multi-door courthouse, if you do an independent mediation, you should be able to take it in for registration for enforcement. What does that make you? A multi-door courthouse practitioner. So in rounding off my intervention, let me say that I don't have all of the answers. I've only set a tone for discussion so that we begin to look at this and find out how else can we begin to promote mediation in a win-win process for all that are involved. I want to thank you.
Thank you very much. Thank you very, very much, sir, for this wonderful contribution. We are grateful. Sir, may I just ask a follow-up question? We have looked at the role of mediators and the multi-door courthouse, the role of lawyers and the multi-door courthouse in promoting ADR. Now, many of these inductees have been trained, they are certified. Upon their induction, they will go around saying they are mediators. I remember someone reaching out to me and said, if I do the training, are you going to employ me? You know, so I was just wondering. So, with your experience as a lawyer, as a journalist, and as a mediator, what advice will you give? Are there already made jobs for mediators, or what can they do to be able to add value both financially and otherwise to themselves?
There are no white-collar jobs already made jobs for mediators, unfortunately, at this time of the process of mediation and ADR. Majority of what people can do are self-employment, self-engagement. And that is why I said to market as flexibly as a mediation advocate. Because if I get to know of a dispute between two parties and I go to them and say, please hire me, I'm a mediator, I'll resolve the matter for you. There is a likelihood that one or two parties who buy into this see you as a business partner. They expect some kind of give back for the business that they are giving to you. So in that regard, I stand to be corrected. In that regard, it might be a little difficult to market mediation on a one-to-one basis, except through the social media and through advertisement in the newspapers. But then for those who are lawyers, another issue arises. Wouldn't this look like seeking for business in a way that might offend the legal practitioner's professional conduct? That is for lawyers. So issues that arise. But if you are experienced enough and you've been able to showcase your expertise in a particular field, more people will come knocking on your door. But that will take a longer period than for a mediation advocate who can just intervene between two people and say, oh, this dispute you are having can be resolved alternatively. Let me take you to mediation. And one of the areas I would suggest is that those who are trained now should collaborate with mediation advocates and mediation advisors, or even with the multi-door courthouses themselves. If mediation's uptake gets to what we actually expect, the multi-door courthouses should be able to farm out cases to independent practitioners. And in fact, under some civil procedure rules, there is a provision that the courts should be able to farm out cases to independent practitioners. Aside the multi-door courthouses and mediation centers, the Lagos rules, I am aware of that, provides that they can be farmed out to private practitioners. But how would these private practitioners be known? That is one of the visions that we have for the Multi-Door Courthouse Practitioners Association. If the association is able to gain the traction that we expect, then of course some judges might be able to look that way for independent practitioners who are assessed as credible to be able to receive cases directly from the courts. But beyond that, partnerships. And again, like the Leonard Sands, Leonard the senior advocate said, there is a need for niche practice. If mediators, there's nothing stops mediators from coming together as a chamber or as a group and exploiting some sectoral areas to say, this is maritime. We are mediators. I want to provide independent mediation for you. Discuss with the leaders of the environment. Set up a mediation center, or even use one of the offices of the organizations there as your mediation meeting point, where matters can be referred to you. Business is done between people who know themselves. So if in the maritime sector, they know a group of mediators, independent mediators, who can resolve matters for them, they would find a way. Aside maritime, there is insurance. Aside insurance, there is transportation. Aside transportation, There is the market of art and all of that. So the field is so large that we should not all be scrambling for positions in the panel of neutrals. Panel of neutrals of an organization that does not have sufficient clients, we should be the people that should build the clientele and pass them on to the multi-door courthouses. If they create an enabling environment where we can do business with them profitably in a win-win position. That is my idea. Hello.
All right. Thank you very much, sir, for that wonderful contribution. Having said so, I want to go on to our very own Samuel Orobosa Osaenen. Is someone who has been very, very instrumental in the promotion of ADR in Nigeria. So, Mr. Samuel, sir, with your practice as an ADR practitioner, as a trainer in arbitration and mediation, would you want to give us a perspective, just a brief highlight of how this new Arbitration and Mediation Act actually enhance the practice of mediation both in Nigeria and internationally, bearing in mind that, you know, most ADR practitioners or lawyers were actually afraid of utilizing the process due to one or two issues, like the fact that you cannot compel a party to appear in courts in mediation session. You know, you cannot compel a party to appear, and this concept of mediated settlement, and after mediation the agreement is not enforceable compared to arbitration. So please, can you talk to us about salient point of this act, particularly as it relates to mediation, so that the inductees will have a good perspective? Thank you. Mr. Samuel.
Thank you so much, and good morning to everyone. Please confirm you can hear me.
Yes, we can.
Good morning, my Lord. Good morning, my Lord. A very good morning to our keynote speaker, Dr. Agada Latiesien. Good morning, Mr. Fine Anagwesien. Good morning, Sir Valentino Burr. Let me start by saying, when I got the invitation to be part of this panel, I said to myself, who am I to be a part of this highly rich and esteemed panel? It is a great delight for me to be here, especially taking into consideration the fact that the vessels that the Almighty God used to introduce me into ADR are part of this panelist. Dr. Agada Lati SN was the chief priest that inducted me into ADR in the year 2021. And I also remember meeting Sir Valentino Burr in the year 2021 in the Edo State Settlement Week. He was part of our resource persons, and I had a very fruitful engagement with him. I want to appreciate you all for your encouragement thus far. My journey would have not been any colorful, successful without your consistent support. Thank you, thank you, thank you. Now to the topic before us. It is well known. It is well known that the Mediation and Arbitration Bill was approved by the Nigerian Senate in May 10th, 2022, and it was finally signed into law on the 26th of May, 2023 by the then President of Nigeria, and it repealed the Arbitration and Conciliation Act of 1988. Now, distinctively, The Arbitration Mediation Act 2023 is divided into three parts. We have part one dedicated to arbitration, part two dedicated to mediation. And the part that speaks to mediation is from section 67 to section 87. And it will be unjust for me to proceed without paying my high respect and high regards to the committee that doctored this act under the able leadership of Mrs. Fumi Roberts. We had notable panelists, notable committee members as Chief Bayo of USAN, Prof. Paul Idomije, and a whole lot of others. There about 19 or 20 of them. Now, the act establishes mediation as a distinct dispute resolution process. Now, we know that before now, there was no national document, no national provision, law or statutes that gives backing to ADR. And this act is so unique. It takes time to define what mediation is, and the act reflects a progressive and inclusive approach to alternative dispute resolution, speaking to enforceability of mediation agreement, confidentiality, mediation agreement, settlement agreement, and spotlighting the fact that mediation is without any form of prejudice. It also highlights neutrality. Now, looking at it from the global perspective, what are the implications of the Arbitration and Mediation Act on a global scale? Now, the Act helps to align our ADR practice within the shore of Nigeria with international best practices. It is well known that the AMA 2023 aligns with the UNCITRAL model law and the Singapore Convention on Mediation. And this promotes the adoption of global best practices in mediation. It helps to bring ADR within the Nigerian space to speed at a global level. And this has enhanced the Nigerian community as an international ADR hub. The act contributes to Nigeria's efforts to becoming a leading international ADR hub, attracting foreign investors and promoting cross-border dispute resolution. The AMA 2023 also seeks to position Nigeria as a competitive destination for international alternative dispute resolution. Now, by providing a clear legal framework and promoting the benefits of mediation in Nigeria, the Act encourages parties to consider mediation as a preferred dispute resolution method. The Act also strengthens the rule of law in Nigeria by providing a transparent and a preferred efficient dispute resolution method. Now, it also sets a precedent for other African countries to adopt similar legislation, speaking from the regional level. The Arbitration and Mediation Act 2023 facilitates resolution of cross-border disputes involving Nigeria parties and other foreign parties. The Act provides a clear and predictable legal framework, and this fosters confidence among domestic disputants and international disputants. The Act holistically engages and increases investor confidence. It aligns with international standards, and this can attract foreign investors seeking a reliable, a predictable, and an efficient dispute resolution mechanisms. The Arbitration and Mediation Act of 2023 contributes to global consistency within the ADR space. Now, it is expected that the Arbitration and Mediation Act will promote a culture of alternative dispute resolution in our legal system as stakeholders and legal practitioners adjust to the new legal framework, leading to a more effective and efficient and amicable dispute resolution. I haven't said this, making reference to the very rich foundation laid by Adnan Sikh in his keynote address. We must understand that the Arbitration and Mediation Act, being new, does not in any way mean that mediation is new in Nigeria. Yes, it is the first national legal framework for the practice of mediation. But ab initio, we've had mediation practice in Nigeria. We are all well acquainted with the fact that the first multi-door courthouse in Nigeria and in Africa, as it were, the Lagos multi-door courthouse, established in the year 2002. You can see the timeline between 2002 and the year 2023. Not forgetting the Citizen Mediation Center that was established in 1999. I'm aware that the Abuja Multi-Door Courthouse was established in the year 2007. The Edo State Multi-Door Courthouse was established in the year 2017. This means that mediation has been on at different levels before the introduction of the Arbitration and Mediation Act 2023. How has this been? It implies that there have been different frameworks, different legal frameworks that have given backing to mediation within the shores of Nigeria. Different states in their different civil procedure rules have orders that validate the practice of mediation within the state. We are aware that in Lagos State, Order 24 of these High Court Civil Procedure Rules and Order 25 give backing to ADR. Federal High Court Civil Procedure Rules 2019, Order 16, 17, and 18. The Edo State Civil Procedure Rules, Order 26. Rivers State High Court Civil Procedure Rules, Order 20, 21, 22. And for other states, gives backing to mediation. But the Arbitration and Mediation Act gives a national embrace, gives a national legal framework to mediation, as it were. And I'm of the opinion that this is just the beginning of more fruitful years to come, because as it were, there will always be opportunity to review and to improve on what we have now. I may not want to dabble into the fact of the different school of thought regarding the processes that was being explained when the act was signed into law. But I'm confident that we are appreciative of the fact that we have a legal national document that embraces ADR. It is disheartening to note, like has been highlighted by some of the panelists, that even in our local jurisdiction, we still have some form of constraints. We still have some form of resistance to the practice of ADR. Imagine a professor of law coming to an ADR session with a preliminary objection. Imagine a legal practitioner saying parties should not be made to submit to mediation. They should be allowed to exhaust all their resources in litigation. When they're exhausted, it is easier for them to resolve when they're exhausted. There are challenges. Much has been done, and there's much more that needs to be done. But we are saying, let us appreciate what we have now. Let us appreciate where we are now, and let us be further encouraged to improve on the practice by laying hold to the code of conduct. Remember, in the voice of one of my mentors, Ambassador V.A.A.A. Ojaide, he will always say to us that as medical doctors, you put on your apparel when you want to perform your medical duties. And when you are done, you take them off. As an engineer, you put on your engineering gadget when you are inside working. But as ADR practitioners, as mediators, our apparel is being infused to becoming our skin. It is a life skill that we must exhibit. It must have direct impact in our lives, in the way we structure our lives on a daily basis, the way we relate with others, the way we relate with our families, and hoping that going forward will make the world a better place. We are simply saying that the Arbitration and Mediation Act has brought national stability. And if we have this, There's still much work to be done. A big welcome to all the inductees. Welcome to the world of ADR. It is a world of endless possibilities. And we do hope that as we progress, the joy of this induction will not wear out suddenly. Keep the kite flying, maintain your passion, locate mentors that will support you and sustain your passion. And going forward, we do know that ADR has come to stay and it will always get better. Thank you for this opportunity. I appreciate you, and high regards to all my mentors in the house. I appreciate you. I do not take this opportunity for granted. Thank you. Thank you. Thank you.
Thank you very much, sir, for that wonderful presentation. Then one more question for you in like 2 minutes, please. These inductees are there, they have been trained in mediation. Would you like to share with them? I know you're one of the young rising star practitioner in the ADR sphere. Will you share with them some of the career opportunities that are open to them in the field of alternative dispute resolution or conflict resolution? Just 2 minutes, please.
Thank you so much, Mr. Nachang. Let me make an attempt to expand some of the issues that have been raised earlier by my highly revered mentors. We all know that the world of ADR is a world to all. Regardless of your discipline, regardless of your skill, you have a space and you have a place in ADR. That means if you have your primary and your primary discipline, whatever it is, where do you fit in? We must be able to identify our passion. Why did I make up my mind to become an ADR practitioner? That is very crucial. A good understanding of your passion will give you stability and focus. Having understood your passion, we must understand that even in mediation, the same way we have areas of specializations in different professions, we have areas of specialization in mediation. As a mediator, you can specialize in family mediation. There are different branches. You can specialize in workplace mediation. You can specialize in communal mediation, as the case may be. Now, going forward, you can earn revenue as a mediator. A mediator is a third-party neutral that assists parties, disputants, have a clear understanding of their dispute and enable them to reach a settlement agreement. You can act as a mediator and earn your revenue as a mediator. Moving forward, you can act as a mediation advocate or a mediation advisor, like Sir Valentino Bro said. What does it mean? The way a legal practitioner plays a critical role to litigants in litigation, you can become a coach to disputants in mediation. Actually, I believe that in mediation, the persons that you accompany disputants to mediation are mediation advocates, those that have the skill in mediation. So either you are a third-party neutral or you are accompanying disputants into a mediation session to assist them add value to the process. You can also hone your skills in training and facilitation. We all know that when you engage in training, when you are a resource person, that can be an area of specialization. There are some persons as mediators, they are specialized in ODR services. They may not have the leisure of time moving from one place to the other. They are domiciled in one location and rendering their services. You may not have the opportunity of becoming a mediator, of becoming a mediation advocate. You may become a consultant in ADR related matters. As we all know, within the mechanisms of ADR, there's what we call expert determination and early neutral evaluation. When disputes arise, parties may even make resort to you. Please, I have this matter. I need a word from you. I need your counsel in knowing how to go about the matter. As a consultant in this field of ADR, you may decide to assist them, give them ideas, and you get revenue for it. We are simply saying that there are different things that can be done, but you must understand your purpose. You must carve your niche. You must understand your style. At this level, it may be difficult to shift. Where do I go? Who do I want to become? And that is why we must take advantage of our relationship with Settlement House ADR Institute and all the faculty members and the highly revered panelists that have given us their time today. We can connect with them and with time begin to clarify our purpose, know where the feelings lies, know the direction we are tending to, and pursue it. And may I end by saying, it is one thing to be trained. It is another thing to keep on training yourself. The level you've attained is just one of the countless levels of training you need to expose yourself to. There are a whole lot of trainings. It is regrettable in this It's regrettable in this jurisdiction that the cost of training is so high, but what doing well. You need to keep training yourself. Volunteering is very critical. At this level, nobody may want to give you the type of platform you need, but we can start from where we are. Volunteer your services. I always tell people, if there is an opportunity for you to put into display whatever skill you have, what is it you can do? Tag along with mentors, tag along with ADR institutes, volunteer yourself, attend trainings, attend webinars, make yourself useful, read up articles, take advantage of the social media space, display what you can do. You never can tell who is seeing you. I'm a civil servant, a core civil servant, but I've decided to maintain my passion in ADR. Yeah, I'm going. I've taken more than 2 minutes. I wouldn't know if I've been able to answer your question, but within the limited scope of my knowledge, I've just made some expressions that have more light into what I've said. I think I've spent more than 2 minutes. Thank you, Mr. Nachang.
All right, thank you very much. Thank you very much, the panelists. Finally, on a fatherly note, I will call on our keynote speaker, Dr. Elache, to give these inductees a marching order, particularly in respect of ethical considerations, in terms of ethical consideration in the practice of mediation. Please, sir, just briefly, and then we will go into the main swearing in ceremony.
Okay, distinguished inductees, let me just by way of conclusion, just to say that, first of all the panelists have done very well, and I thank all of them for all their contribution. And I don't think that these inductees, you understand at this moment the value that you have gained today. So my advice, just in keeping with what my good brother Samuel said, is identify possible mentors and work with them for your growth. But on the issue of ethics, you cannot grow if you begin to cut corners. Like in every other thing in life, you must do what is right. The same in the practice of mediation. Mediators are expected to be neutral and impartial in all respects. And we must, in our conduct towards parties, in our conduct towards the issues that are brought before us, uphold those standards. You must also, of course, remember that the fundamental principle of mediation lies in the fact that we recognize that parties have the capacity to solve their own problem, and that the job of the mediator is to guide them towards that. So even from that perspective, there are ethical issues that you must always keep in mind. Above all, mediator, the mediator is the person who will grow the mediation practice. So as I always say to participants, if people do not have confidence in you, or if by your conduct you diminish what the practice of mediation is, you are harming three particular industries or three institutions or three bodies. You're harming yourself for the confidence that parties will have in you. You're harming the institution that holds you out in that regard, and you're also harming the profession of mediation. What mediation is today is born out of the hard work that some of the people on the panel who have spoken today have carried over the years. And you've heard the testaments from Valentine, from Mr. Anago, and from all others, and my Lord herself. I enjoin you to please embrace the practice, uphold the highest standard. And also, before I forget, you must not mediate every matter that comes to you. You must not serve as mediator. There are times when you've been invited to act as mediator. It is obvious that there is a conflict of interest. Walk away from it. Do not take on every matter and any matter just because you want to earn some money. I can assure you that you will get a lot of respect when people know you for your name and not for what you have. I conclude by saying that your appointment as a mediator will always be based on the fact that people have referred others to you. So word of mouth is the greatest tool. Every other thing we do, put yourself out there, everything you can do, but the greatest thing that will attract work to you is where people say that that person is good at what they do, has integrity, and if you work with them, if you submit your dispute to them, you are sure to get a fair process, which hopefully will lead to an outcome that you'll be happy with. Distinguished, my lords, Chairman of Council, distinguished ladies and gentlemen, I thank you for this opportunity, and I will beg that you excuse me from the formal induction ceremony as I have another engagement which is already started at 12 o'clock. I was just waiting to be able to give this brief remarks, and then I will exit. Thank you very much.
Good afternoon, my noble mentor.
Thank you very much.
Please, can I quickly thank Leonard Silk for being with us? Just give me a minute. I hope he has not gone out.
I'm still here, ma.
Leonard Silk, good afternoon once again, sir.
Good afternoon, ma.
We are honored to have this above Harvard stuff that you have given us.
Thank you, ma.
Please, I will kindly ask that you share your paper with us so that we can use it and keep reminding the inductees that it's a very rare privilege for them to have you speak to them as a keynote speaker. We are very honored, sir. Thank you very much. We're meeting again on this platform. I also want to say I am following steadily behind you, your footsteps, and thank you for setting the pace. Thank you for helping us to know that you can do this with integrity. We're following after you. We're honored and we're grateful. Thank you very much, sir.
Thank you for your kind words, man. Wonderful opportunity that I've been given. Have a wonderful day, everybody. God bless.
Thank you so much. We appreciate you, sir.
So, Your Excellency, ma, can you also appreciate the other panelists as we go into the induction ceremony?
All right. On this note, I would like to thank my Lord I know my Lord very well. Her timing is very, very crucial to her. You give her 9 o'clock, she will be there before 9. And she's allergic to late coming. My Lord, thank you very much. We have been traveling this terrain of ADR for a long time, and I'm honored to have you grace our induction. We're very grateful. To my elder brother who introduced me, I said, let me reserve it for vote of thanks. Mr. Ifeanyi Anago is my elder brother. He directed me to train in ADR over 10 years ago. So I want to report back to you that your reference has yielded so much result. I'm now a fellow of the Institute and a member of the Governing Council. Thank you for sending me to the right institute for my training. I am honored. Not just that, we have been together in many forums. I appreciate you. We miss you in Kaduna. Please come again and let's see your face one day. Or you invite us to Abuja. Thank you very much, sir.
Thank you.
All right. Thank you very much, Your Excellency.
Mr. Valentino, I almost applied for an amendment of your name because I know the name to be Buro, and then when I heard Nanchan calling a different name, I was confused. I'm happy that you corrected him. Thank you very much, sir. You're always apt. Thank you so much for always being available with us, the ADR practitioners. We've also met at the multi-door courthouse practitioners in several forums. I am honored to have you grace our occasion. My own
Thank you very much,
brother,
ma'am.
Osareren, the ambassador of peace. You are a great man. Thank you, thank you, thank you. You're not just a resource person in Shati, but you're always available when we call upon you. We're very honored to have this caliber of intellectuals. I want to congratulate the inductees before time because the people that spoke to you this morning, if we ask to pay them to come and speak to you, we will not afford it. It's a very rare privilege to have them. And you have seen somebody that has developed, especially the MedCom and then lead med. So I will also want to tell you that Lionel Silk is not just a mediator, he's an arbitrator, and he has used his mediation skills very well in arbitration. So I would like to enjoin you, when you get your mediation skills, add your arbitration skills to it. It opens many doors for you. And like he told you, he's on his way to Ghana to go and do a mediation and he will soon fly somewhere else. And so once you are an arbitrator and you're a mediator, your market, you will be making reference to other people because you have a very full house. Why? Because I have also used mediation skills in my arbitration skills. A good arbitrator must have mediation skills, and a good mediator should have arbitration skills to open more doors. Thank you very much, all the resource persons. Thank you very much for your time. Thank you for being around. We're glad to have you, and we will call on you anytime. And I wish you safe journey, even though we're not traveling, we're all virtual, but wherever you're going, I pray the Lord be with you. Thank you very much.
Amen.
God bless you.
Thank you so much, too.
Thank you very much, Your Excellency. Now it will be time for the inductees to take their induction oaths, and I will want to introduce formally the.
Can I confirm if the other resource persons will still be in the house or they are going?
Well, I'm here. I'm here for now.
Okay, thank you very much. Thank you, sir. Thank you so much, sir. We appreciate you. All right, Mr. Nancha, please go ahead.
Okay.
Hello, sir. I can't hear anything.
Yeah, I think preparation is being made to allow inductees take their oaths.
I can also hear.
I'm sure that is what Mr. Nachang is working on. Yeah, let's just be patient. I'm sure preparations are being made to allow inductees take their oaths. Let's just be patient, please.
It's time for the inductees to take their induction oath, and we will want to formally introduce the inductees to my Lord, to Her Excellency, I don't know if you can. I don't know if you can hear me.
I can hear you. I can hear
Yes,
you.
sir, we can hear you.
If you're finding it difficult to share their pictures and profile, just call out their names. Let them indicate their presence. Let's be sure that they are all around in the house.
Okay, so here we'll just introduce the inductees, and we have here a little a video that captures every inductee. And so Your Excellency, as the chairman of the governing body of Settlement House Area Training Institute, I present to you distinguished associates of the I present to you distinguished associates of the institute who have passed their assessment as associates, and they are ready to take their oath. Here are the list of the participants and their names for your kind consideration.
Thank you very much, Mr. Nanchang, the Chief Executive Officer of Shati. Before we go into induction proper, I will just say a word. And it looks as
These are
if
all the participants, Your Excellency.
Okay, I can see them.
We have
So,
Mr. Dauda Umaru, we have Nwe Kelly, we have Paul Jibril Ibrahim, we have Elizabeth Nafisat, yes. These are the inductees that are presented before you.
okay, are we ready?
Yes, Your Excellency, I don't know if you can see the inductees.
I am seeing them. I can see them. I'm seeing all of them. I'm seeing as you're displaying, I'm seeing them. So let's go to the induction proper. But before then, I would just like to just say a very quick one. That's this induction ceremony is not just a mere exercise. It is an obligation upon you as a mediator to uphold the tenets of ADR. Just like the medical doctor will take the hypocritical oath to protect life, it is the same burden that is placed on your shoulders to protect confidential information from the parties that will be before you, and to observe all professional ethics, all the rules of any profession you belong to, and then the profession of ADR. I usually say that if you're someone that talks a lot, it's difficult for you to be an ADR practitioner, because an ADR practitioner must be discreet. And I'm happy that you have heard from seasoned practitioners, respectable people in the society, captains of the industry of ADR, speaking to you this morning. What has distinguished them in this practice is observance of professional ethics and the protection of the oath you're going to take this morning. So please note that you're taking a very solemn oath, and with all sense of responsibility, you will still give an account of it before God. Because you're taking an oath, it is an oath, and you have also made up your mind that you will keep confidentiality. Kindly abide by it. Mr. Nanchan, it's echoing. Are you using a different device?
You can continue, Your Excellency.
Okay. So this year, the 31st day of August, 2024, having participated in the training, participated in exercises, you wrote your assignments, you also participated in role plays. Today, being the 31st day of August 2024, is a day we will formally induct you as you take your oath of induction and affirmation to Shati Settlement House and ADR Training Institute to abide by the oath of our institute and professional conduct expected from all ADR practitioners. And so you will repeat after me. But in case you feel you will not be able to fulfill this oath, I will plead with you not to take this oath and don't practice as a mediator.
Please,
But I don't think you will come this far and then you will drop. We can always grow after we have learned, and we keep learning. So do we all have the oath with us? Display it on the screen.
Yes, ma'am.
Or you have sent it to all of them?
Yes, they all have.
We've signed and
you have signed and submitted. All right. So let's do the physical exercise.
So please, can all the inductees put on their cameras and raise their hands as they take the oath?
Inductees, put on your camera and just raise up your right hand. And then you repeat after me. So when I say I, you insert your name, and then we'll continue from there. So I
Helen Oga Anuchi,
as an associate member of Shati,
as an associate member of
do humbly and voluntarily agree to follow
do humbly voluntarily
voluntarily agree to
follow,
respect,
respect,
and abide by the
promote,
Institute's professional ethics
and abide by the
and abide by
by the
the
institution
institute's professional
and code of conduct,
and code
code
of
of
conduct,
which I was taught in the
which
course
I was the course
which I was taught in the
of
course
my training,
of my
course of
training,
my training,
in
in
the
the
course of
course
my
of my
training,
training,
as well
abide by the
as
rules and
diligently
regulations of the
abide
institute,
as well
as
as
well as
diligently abide
diligently abide
by the rules and regulations of the Institute,
the rules and
rules
regulations
and
of the
regulations
institute.
of the institute.
I will discharge my
as an
responsibilities and
alternative
duties with
dispute
passion.
resolution practitioner,
As
An
alternative dispute
alternative
resolution
dispute
practitioner,
resolution practitioner.
I will discharge my responsibilities and duties
I will discharge my responsibilities and duties
with professionalism,
with professionalism,
honor,
Responsibilities and duties.
integrity,
integrity,
neutrality, and impartiality, and I will not engage in any behavior act or conduct that will tarnish the image and name of the Institute
Image and name of the institute,
or the practice of alternative dispute resolution, ADR, in the event of any allegation of professional misconduct against me,
in the event of any allegation of professional misconduct against me,
professional misconduct against me,
I willingly and voluntarily accept the results
I willingly and voluntarily accept
The result
of the investigation,
of the investigation
discipline and or decision of the governing
and or
body of the
decision of
institute,
the governing body
and the decision of the governing
of the Institute as final,
of the institute as
decisions of
final,
the institute as final,
including the withdrawal of my license and certificates.
including the withdrawal of my license.
of my license certificate.
In all matters coming before me,
in all matters
No matters coming before me,
I will discharge my responsibilities with honesty and fairness.
I will discharge my
responsibility with honesty and
fairness.
Fearless.
So help me God.
So help me
God.
Congratulations.
Amen.
You're welcome, Shati. You're welcome to the ADRs
Thank
here.
you, Ma.
Thank
You're
you, Ma.
welcome
Thank you, Ma.
to the profession that is dear to the heart of God.
Thank
Go
you.
and be peacemakers. Thank you very much.
Thank you. Thank you. Thank you.
Mr. Nanja?
So help me God. Amen.
Thank you very much for that wonderful session. I want to officially congratulate all.
Thank you, Ma.
I want to congratulate all the inductees for this their induction oaths. Thank you very much for availing yourself. Thank you very much for availing yourself for to take your induction oath, and we pray that God will help you in your professional career as a mediator to be able to meet up to your expectation. So, having said so, we want to call on the participants, maybe a representative of the participants, a male and a female, to give a closing remark on behalf of the inductees before our closing prayer.
Can I come in?
Okay.
Can I come in?
Yes, go ahead.
Okay. Your Excellency, the Chairman of the Governing Board.
What's your name and then before you proceed?
I am Yakubu Moses Ede, the newly inducted associate with Shati. May I stand on
Your volume, I can't hear you very well.
Okay, I said first I want to acknowledge the effort of the chairman, governing board council, that is particularly Your Excellency is Roskana, and then all other. I want to appreciate you for a day like this. This is a journey that we started quite some time ago, and then within the short period of site training, it was quite insightful and quite rich and eye-opener, and also it brought our horizon in several ways. So for us today, doctors fully into being associate of Shati or mediators in Shati. Well, thank you. And we'll do everything possible to uphold the conduct, the professional ethics, just as one is about what keeps you going any moment is your ability to ensure that you uphold the ethics of the profession you belong to. Now, quoting Her Excellency that said, welcome to the profession that is so dear to the heart of God. Certainly, since a profession that promotes peace, God is always happy in seeing people living in harmony. So in view of that, on behalf of my other inductees, or now new do everything to see that we add to the knowledge we've acquired and then also improve ourselves by participating in different programs, more trainings. Then if there are instances that will call for referral, we always do our best to refer to settlement house so I can altogether promote it, because it's not easy having such a body in a distance and then give it, to do our best also give the global outlook where the need is. Thank you so much, and I hope that the doors of Shati will always be open to us to come and use it as a venue for settling some of the matters that will come our way in the event that we have any, and also that anytime we can always call Shati, particularly through our WhatsApp platform, to now make the query when we have some input in terms of our experience out there. Because we might have 15 years experience in a particular profession, but indeed, we're now also new. So since we are new in this, whenever we have any challenge, we always call on you, come to you for guidance. So thank you so much. We are most grateful. Thank you for your time. Thank you so much.
Thank you so much for being part of this induction this afternoon.
Thank you very much.
Thank you very much. Do we have one more person of the female gender?
Yes, Josephine, who wants to speak on behalf of the female gender?
Go ahead, please. Thank you.
Okay, can I go ahead?
Yes.
Go ahead.
Okay. I really want to, it's a delight for me and on behalf of my fellow inductees, just like my fellow inductee has already said, rightly said, he has actually captured a lot of the things I wanted to say. Permit me to just add by appreciating our versatile members who took their time, our trainers during the training session. We were, introduced to a lot of things and a lot of possibilities during the training. Our eyes were opened to things that we never knew were there before. And their rich resumes and how they were able to teach us in a manner that we could understand and it could stick up to now is something we always appreciate them. And today again, with people from diverse backgrounds with wealth of experience in various segments of the ADR practice have spoken to us again. I am particularly thrilled and happy about all, but particularly one of the speakers told us about LeadMed. That is for those of us that are in advocacy or litigation. Sometimes you look at it and you wonder how it can, how you can navigate through. And introducing that LeadMed, beginning with litigation and going into mediation, is an aspect that I'm so thrilled about. And also the fact that we should look at specific areas so that we can specialize and focus on. I'm already beginning to look at my environment, tells me that we should look at our immediate environments first, the gaps and how we can come in. And the fact that there are various areas that we can practice. Someone mentioned the oil and gas sector and all of that. So we were encouraged today about the fact that there are endless possibilities in ADR. We are hoping, by the grace of God, to make use of all these opportunities that have been given by Shati and all our trainers.
Hello?
Honesty, dignity, and be able to showcase the beauty of Shati to other people, and also utilize every opportunity we have to showcase Shati on every stage that we find ourselves. So I want to really say thank you finally, and we look forward to having a beautiful opportunity to be able to gain more from our trainers, from their wealth of experience. We hope that when we come, your doors will be open to us as we are ready to learn. Thank you so very much, and God bless.
All right, thank you very much for that wonderful contribution and the closing remark. Finally, I will hand over to the chairman of the governing body to, before we go, we have a member of the governing body, Mr. Ifeanyi Augusti, with us. Please, can you just give us a closing remark, and the chairman will now close us. Mr. Ifeanyi Augusti. Mr. Ifeanyi Augusti, are you with us, sir?
Hello, are you hearing me?
Yes,
Okay.
sir, we can hear you.
Okay. I said this is particularly directed to the inductees. And it's just to support what every other speaker had said. The sky is your limit. Somebody said, I put myself on fire and people came to watch me burn. That's John Wesley. If you put yourself on fire, people will come to watch you burn. You can become useful in so many dimensions, so many areas, but you can't sabotage the issue of integrity, ethics. And as you go out there, just like the learned six said, it's word of mouth that will market you. So maintain your integrity. Above all, trust God, that God will make a way where there is no way. And as we see again, we'll celebrate you. Thank you very much.
Thank you, sir. We appreciate
Thank you very much, sir.
Yes, thank you. Ma, you can go ahead and then close the ceremony. Then just a brief announcement for those who are available to collect their induction packages.
All right. Thank you very much, my elder brother, Mr. Anago. It's an honor for me to meet you again at this forum. Thank you for your time. Thank you for your patience. Thank you,
I'm having
my
a
Lord.
training.
Thank you for your patience. Thank you, everyone, for being available. On a final note, before I give the closing vote of thanks, I want to assure you, because I know that in different forums, people that are used to the Arbitration and Conciliation Act are advocating, why did they remove conciliation and all of that? Now it's now resting on your shoulders to educate people that actually conciliation is not removed from the law. It has been given a glorified body. Both mediation and conciliation are already baptized into one name, one body, which is the mediation itself. But when you scan through the act, you realize that the practice of mediation as encapsulated in this very new act is actually partly conciliation. And so we have also mentioned that conciliation and mediation in the international fora is used interchangeably. And another interesting aspect about mediation is that by virtue of Section 82, subsection 2 of the Arbitration and Mediation Act, once a mediated settlement agreement has been signed by both parties, it is enforceable as a contract. You have three options. It is also enforceable as a consent judgment. It is also enforceable as an award, consent award. And you remember you heard our mentor talking about Medcom, how the result is a consent award. Very, very important. So you have these three options to enforce. And I will gladly say that go for consent judgment once it is a mediated settlement agreement. Present it to the judge as consent judgment, and that seals your transaction. Even though it has the same efficacy with consent award as a contract, but in order to help lawyers understand, because lawyers are still finding it difficult to understand why all of this. This is to help lawyers understand that this is where this ship is heading to. And like my Lord says, ADR has not come to take away the lawyer's job, but instead it has come to butter its bread and other professionals. So on this note, I would like to say thank you so much, our resource persons. We're very, very glad to have you. I'm very honored to have you. We appreciate you. And we pray that the Lord will bless each and every one of us. And for the inductees, I would like to say congratulations on your induction. Go and volunteer. Just start with volunteering. Don't say, well, nobody has invited me, nobody has referred me. It is from volunteering that people will know you. If there is any conflict anywhere, just volunteer and give your advice. Start with giving advice and you move. Before you know it, references will be coming your way. Thank you very much. And on this note, I would like to draw the curtain and say, let's meet at the point of collection of your materials And for those of you that are unable to collect, we'll still fix another date for you to come and pick it. Thank you very much, sirs. Thank you, my lord. Thank you,
Okay,
Mr.
so I saw
Reverend. Thank you, Mr. Valentino. Thank you. My regards to
one of the
Lynette
kids.
Silk. We're very grateful for your time. God bless you.
All right. Thank you very much, Ma, for that wonderful closing. Mr. Samuel, I saw your hands up.
Yes, please. Appreciation to everyone for your input in making today a success. I think so much has been said. There's one thing that we are forgetting to say, or we are refusing to say. With due regards to my Lord, with due regards to a highly esteemed HR practitioner, Mr. Nago, and the chairman of the governing council. Today happens to be the birthday of the CEO of Settlement House ADR Training Institute, no other than Mr. Natang Nagwan. Today is his birthday, and your induction coincides with his birthday. I think we need to do something special for him. So over
Happy
to
birthday.
Happy birthday, sir.
Happy birthday, sir.
Accomplishment. God bless you and yours always.
Happy birthday, sir. More blessings.
Thank you.
Happy
birthday. Happy birthday, CEO. Happy birthday to you.
Thank you. Thank you very much.
A virtual birthday badge.
All right. Happy birthday to CEO. I think the presence of all the esteemed panelists and the keynote speaker is enough a birthday gift for him.
Thank you. Thank you, Excellency. I appreciate you all. Thank you.
You're welcome.
On this note, I want to say that for those of you who are available to collect their induction materials, they should indicate on the group so that I think in the next 1 hour, they are about that. Please, if you are available so that we can package yours and take it to the office, indicate in the training group, in the induction group that you want to come and get your package, and then we'll be there to ensure that you get your packages. Please do well to share your induction flyer, share some of these things on your social media handle. Like my Lord will say, make noise about it. Let people get to know that you have been inducted and you are a certified mediator. You are available to assist them, whether voluntarily or otherwise. And please, you can also do well to promote the institute. We have a training that is coming up next week from 2nd to 6th of September. Please, I know you have benefited and you see the nature of our training. If you have some people you want to recommend to take part in this training starting on Monday, please do well to do so. We will really appreciate. And by tomorrow, Sunday, we have the continuation of our webinar in collaboration with Pizza Curious Settlement House, Edward Training Institute, and Pizza Curious Associates Consult. It is on the psycholinguistic, application in area of conflict resolution. Mr. Samuel, you can share that flyer for them to see. We'll share it on your platform. If you have not registered, please do so to register and take part. It's a free webinar. And if you are interested in getting a certificate of participation, you also indicate. For the inductees, all the listed materials, including your t-shirts, including your medals, including your jotters, including your certificate for attendance of this particular training before the induction, all of them are going to be available. I consider you privileged and fortunate, and I wish you a big congratulations and favor as you move ahead in your professional career as mediators. We'll be happy if you can say a word to others about the institute and invite them to take part and pay and register for our forthcoming training. We really appreciate, and we are going to appreciate you especially for that effort. Thank you very much.
Right, CEO, don't forget to
Thank you, sir.
CEO, don't forget to announce that the arbitration training comes up from the 10th to 13th of September. For those that are interested, we'll share the flyer on your platform. Thank you.
Okay, yes. Arbitration training for those who want to become arbitrators is coming up from 10th of September. The flyers will be shared. If you are interested, please you can indicate. Now, on this note, I want to call on our Muslim friends and brothers to close the occasion for us with the prayers. Do we have anyone who wants to close?
Okay. Can I volunteer?
Go ahead. Okay. If you can put on your camera, we appreciate.
Because he been here,
Can you?
Time for prayer. Okay. بسم الله الرحمن الرحيم الحمد لله رب العالمين الرحمن الرحيم مالك يوم إياك نعبد وإياك نستعين الصراط المستقيم صراط الذين أنعمت عليهم غير المغضوب عليهم ولا الضالين آمين. In the name of Allah, merciful, Lord of the day of judgment, you alone we ask for forgiveness and you alone we worship. Guide us onto the right path and your favor, not the right of and your anger. Amen. Thank you.
Amen.
Thank you very much and congratulations to all of you. I want to hear you on the social media and all over. Let's meet and then indicate if you'll be available to take part in to come for your induction packages. Thank you. God bless you.
Thank you, Nansha.
Thank you, sir.
We are going to share the screenshot of the induction, including some of the recordings, so that you can share and listen again where necessary. Thank you and God bless you.
Thank
Thank
you.
you.
Thank you. God keep you for us. Thank you.
Thank you.
Thank you very much. I appreciate.
Thank you, Mr. MK Bello.
Thank you.
Yes, sir.
Mr. MK Bello. Yeah, I said thank
Yes, sir.
you for the closing prayer.
I appreciate, sir. God bless you.
Shati MK Bello.
Thank you very much.
They are not hearing you.
Congratulations to everyone. Congrats.
Congratulations.
You can put on your camera and congratulate one another, greet one another as you.
I'm proud to be associated with the institute. Thank you, Nanchan. Thank you, my brother.
Congratulations, everyone.
Congratulations, everyone.
Congratulations to everyone. Happy birthday to Mr.
My congratulations to all my professional colleagues.
Congratulations, everyone.
Can we sing a
Commissioner? Is it my honor? I can see my honorable commissioner.
My special thanks to Mrs. Nanchang.
Mr. Yanagua, how are you?
She has been so amazing. Very patient with us.
My honorable commissioner.
As well.
I greet you.
Can we sing happy
Everyone.
Thank you.
Mr. Yanagua.
Yes.
Sir?
Happy birthday collectively.
Okay, let's do it.
Happy birthday
Thank you. To you. Happy birthday.
To you.
My voice don't go.
Happy birthday.
Happy
Happy
birthday.
birthday. Happy birthday to
you.
you.
Hip hip
Happy
hooray.
birthday.
Hip, hip, hip.
Happy birthday. Happy birthday. Happy birthday to you,
Yes, I
Mr.
appreciate this choir voice.
Mr. MK Bello.
It's like
Mr. Ede. Mr. Ede. Mr. Ede Nagua.
Yes, sir. My Oga, I'm greeting you,
Yes,
sir. I'm loyal, sir.
I'm inviting you to a special reception.
Okay, sir.
Remember to take us along, go.
My Oga, I'm loyal, sir.
Induction reception.
You should be in Kano in the next 30 minutes, in the next 20 minutes.
Hey.
This is my commitment. Yes, sir.
All right, thank you very much. Congratulations to all of you.
Yes, sir.
Yeah, thank you.
Thank you, sir.
All right, you're welcome.
Thank you, sir. Thank you.